Good morning, good afternoon, good evening. Thank you for joining us from wherever you are in the world today for this session at Copenhagen 2021, examining how we can accelerate the decriminalisation of LGBT people through the use of litigation. We're delighted to be able to join you, albeit virtually, at Copenhagen 2021 to discuss this topic. I'm Alistair Stewart. I'm the Senior Advocacy Advisor at the Human Dignity Trust, and we're proud to be an executive partner to Copenhagen 2021. The Trust is an international human rights organisation that provides technical legal assistance to support a range of different stakeholders who are working to change the laws that criminalise or fail to protect LGBT people. In our 10 years, we've provided support in more than 20 countries to activists and lawyers using the courts to challenge the criminalisation of LGBT people. We obviously believe that this work is vital. Across the world, 71 jurisdictions continue to criminalise LGBT people. Conservatively, more than 100 million LGBT people live in criminalising countries. The good news, however, is that number is falling. Over the past 10 years, 13 countries have decriminalised same-sex sexual activity, bringing approximately 72 million LGBT people out of criminalisation. Now, these countries have decriminalised through a mix of strategies, through litigation in the courts or through legislative reform in parliaments and legislatures. It's 4 countries where the courts have been used by activists and lawyers to achieve the decriminalisation of LGBT people. And we're really happy to have at least 2 of those activists with us today. So while in a majority of these countries, it's been legislatures which have been the mechanism for change, litigation is still an essential tool to defend the rights of LGBT people. This is particularly true where governments are hostile or ambivalent towards our rights, or where they lack the necessary political will to take a legislative route to reform. I think one of the things that is illustrative of that fact, illustrative of the need for litigation, is that at the Trust we're aware of at least 11 countries where cases are underway as we speak to challenge the criminalisation of LGBT people. Before introducing you to our speakers, I'd just like to reflect on some key lessons from our work at the Trust that we think are advantageous when we think about how decriminalisation can be accelerated in the coming years and decades. Firstly, I think it's important to reflect on the fact that litigation can often be a lengthy process. Rarely is it straightforward, and often there are setbacks and course corrections along the way, as well as victories. Many of the cases that we're involved in take up to 10 years to complete, and this requires really kind of long-term commitment and investment from a whole range of different stakeholders that are involved in that process. Secondly, we believe very strongly that a loss in the courts is not always a loss. For instance, some of the most prominent victories in litigation over the years have been preceded by defeats. The example of Lawrence v. Texas in 2003, which achieved decriminalisation in the United States, was preceded by an unsuccessful case in 1986. Likewise, Johar in India, which successfully achieved decriminalisation in 2018, was preceded by an unsuccessful challenge in 2013 at the Indian Supreme Court, which itself was preceded by a successful challenge at the Delhi High Court in 2011. The road towards decriminalisation in the courts is rarely a straightforward one. Thirdly, and I think perhaps most importantly, while there are, of course, many differences between the countries where LGBT people continue to be criminalised, cultural differences, social differences, political differences, and even legal differences, there's much that we can learn from one another to strengthen the fight for decriminalisation. I think in 2 concrete examples. Firstly, of course, courts around the world look to one another for precedent. So it's important that we consciously build on legal successes in one country to strengthen the work in another. And I think perhaps the most important point is that the lessons learned by activists and lawyers, by those expert practitioners who've been through or are going through the process of litigation, are incredibly vital in developing strong, robust, rigorous, and successful litigation strategies, not just for our work inside the courtrooms, but for our work outside them as well. So, to that end, I'm delighted to introduce you to two of those expert practitioners in the field who very kindly agreed to share their expertise with us today. Joining us from Botswana is Mmolai-Chalmers. Anna is a research and advocacy officer at the Southern African Litigation Centre. However, previous to that, for 6 years, Anna was the CEO of Legabibo in Botswana, where she led the organization through 2 landmark court cases, a freedom of association case that successfully challenged the government's refusal to register Legabibo, and as an amicus in a case that successfully challenged the criminalisation of same-sex activity in Botswana. Welcome, Anna.
Thank you.
Joining Anna on the panel is Caleb Orozco. Caleb is an LGBT and human rights activist who for the past 15 years has worked primarily within the field of LGBT rights. He's the executive director and founding member of the United Belize Advocacy movement, where he's worked tirelessly for the eradication of discriminatory laws that impact marginalized communities in the Caribbean. He, of course, was the principal litigant in Caleb Orozco versus the Attorney General of Belize, which is a successful constitutional challenge to Section 53 of the Belizean Criminal Code, which criminalized same-sex activity and was held to be unconstitutional in 2016 and was finalized at the Court of Appeal in 2019. Welcome, Caleb. Welcome to both of you.
No problem.
So instead of this being a kind of a standard panel event, we thought it'd be far more useful and far more interesting to have a chaired discussion. So I'll be asking questions of both of you, and we'll be kind of talking about some of the points that arise from that discussion.
Yeah.
Anna, I guess kind of starting with you, the path to success in the courts in Botswana, I think, has in some ways been a really long one. I think going as far back in some ways to 2003 in a historic loss, and then of course the incremental victories that you have achieved along the way. In the development of kind of Legabibo's strategy, Legabibo's approach to litigation, how important was it to kind of take into account the earlier losses, and how important was it to build a strategy that developed incrementally through the courts?
Thank you, Alistair, and thank you for having me in this panel discussion. Yeah, as you rightly pointed in the background you laid out so perfectly, for when we started the litigation for freedom of association, it was very important for us to really think about, you know, what had happened before, historically what is called the Ganane case. That was lost in court in 2003, because that was a decriminalization effort. We knew that, you know, challenging refusal to register was going to bring up the whole Ganane case, the whole issues around morality, the whole issues around you know, the nation, Botswana not being ready for an LGBT organization, because that's the reasons that also the government used to refuse registration, as we applied over the years, that, you know, the organization would encourage immoral things, for lack of better word, and that, you know, same-sex homosexuality is illegal. Therefore, they cannot register an organization that's going to advocate for illegal aspects, things that are illegal in the law. So it was very important for us to take that into consideration and make sure that the strategy is very clear, that it was about association for me, a movement, and claiming the constitutional rights that every person has, freedom of expression, and include all those things into the strategy, and make it clear that it's not, our litigation is not about same-sex relationships per se or specifically, but it was about people, citizens being able to claim their civic rights, to form a movement or advocate, and protect one another as an association and as a movement, a right that's a constitutional rights that are given to all Botswana. So that was indeed very, very critical. As we've seen later on, it really worked very well in terms of our advocacy, because also what we had in mind is that the strategy needs to be such that it can build positive public opinion towards LGBT persons as well. So that was very, very important for people to understand that we're not challenging criminalization now, but to associate and form a movement, just like anyone else, yeah.
And in terms of kind of making that movement from the freedom of association case, which, as you said, was an opportunity to develop some arguments in court, but also very importantly to start a conversation with the general public about the community. And how did you move from that point that was kind of very focused on constitutional rights around freedom of association to the Decrim case that obviously was about same-sex sexual activity?
I think what the judgment that the court gave really moved us further because of the pronouncements or the statements that were made by the judges, both in the High Court and the Court of Appeal, especially when they made it very clear that in Botswana, being a homosexual has never been a crime, sort of falsifying the assertions that and the assumptions that we've always had, the public has always had, and even the government has had.
And sorry, if I can just interrupt quickly, and just to clarify for our audience who may not be familiar with this particular nuance, it's the act itself that it is the crime. Yes. It's not it's not being an LGBT person. It's not being a gay man.
Yes, yeah. I think that was a really, really strong statement that. One, it surprised a lot of us. It really concretized, made it clear that these things need to be separated, and also the affirmation that one of the statements in the court papers is that LGBTI are part of the Botswana society, diverse and part of Botswana society, and need to be protected by the Constitution, sort of negating the earlier judgments that was made in the Ganane case that the LGBT persons are at the moment not protected. Then were not protected by the Constitution. So that sort of took us further in our advocacy, and also make it clear that as it's part of our constitutional rights as LGBTI to advocate. You cannot refuse an organization that's in objectives. It's saying it's going to advocate for decriminalisation and same-sex relations, because there's nothing wrong with advocating. Every citizen has a right to advocate and participate in civic, responsibilities. So yeah, that really strengthened our thinking around Decrim.
Okay, thank you. Caleb, kind of turning to you, the process of litigation in Belize was also a lengthy one. And my understanding is you from the first sessions of planning through to the final successful ruling in late 2019 was well over a decade. What sort of commitment does it take from individuals and from organizations and from a whole range of stakeholders to see that sort of lengthy process through? Caleb, I think you're on mute.
Oops. Okay, so to answer your question, it's very clear that the process of decriminalization requires an advocacy framework at the national level, and it's not just driven by legal thinking, legal arguments, or legal engagements. Within the context of that advocacy framework, one has to appreciate how do you leverage international human rights spaces with national action to test the psychology of the government. For us, it was important to use the Universal Periodic Review to get a response from government with regards to their position on the Constitution and with regards to their response to LGBT Belizeans. That formed the basis of them understanding the importance of communication, and that communication for us was very technology-based, using social media to drive social debates locally. In regards to expanding that advocacy framework, it was important for us to understand what are the opportunities for bridge or identifying platform issues. And two issues we leverage very well were gender and HIV. Recognizing that the engagement process does not stop because the process of legal arguments and legal filings are taking place. We looked at the issue of research as an important part of our process and documenting opposition talking points to support communication talking points when we were speaking to the media. With regards to the process of engaging the community, it was important for us to at least try to explain what the case was about and recognize that it wasn't going to be hundreds of people in the media, but it was going to be a small core group of people working behind the scenes, driving the conversation and tempering and mitigating opposition, especially within state systems. For us, it evolved into an opportunity to look at what are the socioeconomic rights exclusion that have taken place within the larger discussion of decriminalization. For us, it was understanding or working towards understanding what are the systemic violence and biases that advances trauma to not only LGBT individuals, but marginalized groups as a whole. And we started to build coalitions around disability, gender, HIV, and on issues around gender-based violence to be more specific as the time progressed forward.
So if I could just kind of pick up on some of those points that you've made there, Caleb, and I think it's incredibly important. I think it's fascinating, and I think it's sometimes a failing for those of us that are very focused on the courts, is the importance of the work that needs to go on outside of the actual courtroom in order to, on the one hand, make a case successful, but also to take the best advantage and make the most of the success in that case. Anna, I guess in terms of some of the of your experience in Botswana, and how important was mobilizing the community around the case? How important was communicating the case to the general public? And how important was kind of using advocacy to ensure that kind of senior stakeholders in government were informed of what was going on in the case?
Yeah, this, first of all, the Freedom of Association case was a case around communities, around people, around movement building, the community coming together. That was the message we were communicating to the government, we were communicating to the society and the community itself. To say, Lekgabiwo as an organization is an organization for the people. And there are people who want to be members of this group. Hence, there was more than one litigant. There were like 20 people to show that, there are people who believe that this organization can represent their interests and speak better. So that was the main message around it. Hence also the visibility of members of the LGBT community within the courts and outside. And we flooded, the media with LGBT stories. It could be stories of violence or the stories of success, the stories of victory. But what was important was there needs to be visibility, because a lot of what the stories, the negative stories that were out there is that people would choose to ignore or not believe that there are LGBT persons in the country, and make statements such as it's a Western concept, it's an African, it doesn't hold the virtues of Botswana or African people. So it was important to make that visible using documentation, like Caleb said, using LGBT person stories, and also using research that was done by the government itself. That also became a very important part of the Decrim case as well, ensuring that, there is someone there who is taking on the case, the main litigant, but also importantly, not just relying on the legal arguments, relying on expert evidence, based on research. That was the role of the amicus Lekgabiwo, to provide the evidence to say, this is the impact that criminalization has had on members of the LGBT community. And I think the health aspect, the HIV aspect of our work, or government's work, countries' work, nationally in Africa and even internationally, it became very, very critical because there is a lot of evidence there around the impact of HIV on gay men having sex with men. It became very, very important as part of the amicus to be assessed in court. And also what has always been, it really, the fact that governments have done the research themselves, it gave strength to our arguments and our court, our arguments, and also whether it's legal or even within the public. Yeah, so it was very important to have a very clear communication strategy, just as much as we were avoiding the criminalization part when we were doing freedom of association. The messaging was really very clear around freedom of association. But when it came to Decrim, the evidence was very, very critical, putting it out there, because we know, lawmakers don't exist in an island. They read and so forth. So yeah, it's a very important aspect.
Thanks for that, Anna. And Caleb, just picking up with you on another point, you kind of mentioned the importance of leveraging kind of regional and international spaces as part of a kind of broader advocacy strategy, of which litigation is just one part. I guess to what extent in your case and your planning and your work around the case, did you look to other national examples, what other activists and other actors had done before you? Were there examples that you could pull from that kind of helped you with developing your own strategies for change?
For example, in 2015, I looked at the history of litigation in more developed countries, whether it was Norris versus Ireland, Lawrence versus Texas, and the list goes on. And I asked a very specific framework and I ask a very specific question, and that question is, what is our framework that we're going to work on there? And then I understood that there was a national portion and there was a transnational portion that was important. The transnational part of it was important because of the resources, because of the strategy, because of lessons learned. And it then informed what our national approach was. It was clear to us, for example, that while public communication was important, it was important to target persons who are in position of influence or authority. And in that regard, we look to women to help shape opinion and responses of political leaders behind the scenes. With regards to pushing support, we looked at straight allies who were concerned about what the tone, or in this case, the intensity of people position meant for the lives of LGBT people. And those individuals really had access to resources, access to technical people, and access to political people. And they helped drive the political dialogue for us behind the scenes, at the dinner table, at meetings, in friendly conversation. And so what we realize is that the political leaders of this country, based on the historical lessons of the last 40 years, were not going to take it upon themselves to respect the constitution of beliefs without us forcing them to then drive the conversation about what it means to address the value of inclusive governance. So litigation became an important point. We looked at the history of human rights institution here in Belize, and we realized that there is a very weak system of enforcement and protection. Sure, the state can argue the court is there, but not everybody can afford to go to the court every time there's a constitutional violation. And as a result of that, we developed our own civil rights enforcement mechanism that we simply call a Human Rights Observatory, to fill the gap where the state have absolved itself of its responsibility. In regards to sustaining political engagement, we have continued to do so at the national level through letters, through meetings, through research, through indirect exchanges with our allies, and getting our allies to then reshape the narrative of how political leaders think or respond to LGBT issues. That has been this focus for our lessons from the beginning, and that process has evolved into other areas of concerns for reform.
Excellent. Thank you so much, Caleb. And I think we'll kind of come back shortly, hopefully, to the point about the other areas of reform that you've kind of alluded to then. So Caleb, your case was kind of successfully concluded in 2019. Anna, in Botswana, the situation is slightly different. You had success in the first instance, and the government is currently appealing that judgment. Are you able to kind of give us an update on where things stand at the moment in terms of when you're expecting to be back in court again? I know given the world that we're living in at the moment, who knows what we're doing next week, let alone in 6 months' time. Yeah. But it'd be great to hear kind of what your kind of immediate plans are, or what Legabibo's immediate plans are for the case in Botswana.
Okay, before I get on-to that update, just in addition to what Caleb said about leadership, engagement of leadership and political allies, just to say that it really helps if, the highest office, you know, like the president or the vice president or any legislators make a statement about the human rights of LGBTI in a country, just before the judgment for the decrim, the president of Botswana, who was new in office then, during the 16 days of violence against women, made a statement, whether it was in passing on it or intentional, but it became very critical. Just to paraphrase something around, there are people of the same sex who are experiencing violence, but the law does not support, protect them against the violence within their same-sex relationship. That statement really went a long way. Even if you look at the judgment now, it's within that judgment, went a long way to prove that the acknowledgement and the political will to change. And I think if we can take it a step further, when LGBT community are ready to start advocacy around marriage and so forth, it's going to be a critical statement, just to say that what the leadership think and say is very important in terms of changing the tide and public opinion as a result. And also, you know, as we work on these cases, taking the case out of the court and into the public, those communications that we're talking about are very, very important, because they do change public attitude and public opinion. A barometer that was done after the decriminalization case was won showed a very distinct change in people's attitude towards LGBT in Botswana. So it's very critical, and it shows the role that the judiciary can play in changing people's opinions about other members of the community. Although strategic litigation takes a very long time, which in our case, the first case was 3 years and decrim was 3 to 4 years, it really has, if it's well publicized and put out there, shared with the public, it can contribute into, you know, infusing positive attitudes about other members of the community. So in terms of the next step, like you rightly said, the government has appealed the decriminalization. At the moment, there is no sign as to when it will be heard. Like you said, the courts are done virtually, and you know, limited resources, and virtual court, you know, is still quite very new for governments and maybe a lot of judges and so forth. But we've seen a lot of public interest cases being heard virtually. Just recently, there was a case around the land rights of a tribe, and it was heard virtually, and it worked. So we are hopeful that we would be allotted a date, whether it could be next year. We're still hopeful for that. We're still trying to push for those next steps so that the appeal can happen if it happens, so that we close this chapter and start thinking about, now that we have decriminalized, then what, you know, those actions. Yeah.
Well, we're certainly kind of looking forward to your next day in court, and for you to kind of continue your track record of victory in the court so far. I guess kind of building on that last point, on the point of kind of what next. Certainly, I think it's a question that we're asked as an organization quite often, even though sometimes our mandate closes at the end of a court case. But it is a really important question. You kind of what next after a case is successful? What next for the community? What next for the movement? And I guess, Caleb, I really want to kind of ask that question of you. Your case was finalized in 2019, and how did others in Belize, in the movement, use that case to move the entire community forward, legally and socially?
Well, on the impact of the case, really, when we studied was one organization. Now there are 4 more dealing with LGBT family, trans issues, lesbian and bisexual women, for example. In regards to the legal decision in 2019, what people must understand is you may have a legal decision, you may win, but the political directorate does not have a time frame of amending the particular section of the law, nor does it have any instruction or obligation to follow instruction around addressing what the acknowledgement of equal protection under the law means for the application of new or old laws. These are work of undone business that has to be addressed by an advocacy driver at the national level. The work, or in this case, the acknowledgement of fundamental rights under a constitution does not equal reform in areas of Family Act, reform in access to benefits, reform in addressing violence issues, especially in the Domestic Violence Act. Legislative reform, for me, the CRIM puts a very sharp lens on the inadequacies of our legislative framework, the exclusionary practices of our legislative framework, the weaknesses of our human rights practices, and it exposes the old colonial habit of amplifying violence in a systemic way to advance trauma and subjugating marginalized groups of people. And so the work in my mind is constant in creating agreements or movements of solidarity across issues to then break down the barriers of marginalization that are affecting other groups of people. So the work for us is certainly not done yet after the legal decision in 2019.
And in the kind of in the Belizean experience, and is there a sense that success in the courts, in the way that kind of Anna kind of indicated in Botswana, has created a cultural, a social, a political space to move the conversation forward, to start to address some of the issues that you've kind of highlighted?
Well, in 1981, there was not a single statement from any politician on LGBT issues. In 2013, it was historical for us during the Independence Day speech for the PM in 2013, where he was the first politician to acknowledge the LGBT as an issue. So there is space because we have a shift from tone to substance. The problem with any system is that they're so used to not having a backbone in transforming the lives of marginalized population. And marginalized population are so used to being oppressed that you have this culture of complicity where both parties are either silent by inaction, omission, or indifference in perpetuating the so-called idea that we are all citizens of this country and treated in equal footing. And so the work must continue with regards to pushing political leaders to do more, pushing our community to be more visible. And we see that change where people are posting up pictures as couples, people are coming out as gay, or lesbian, or bi, or trans. We see more images of Belizean LGBT people on Instagram and Facebook. And so there's that psychologist shift is part of, in my mind, an important part of a charm offensive a framework which is evolving as we move forward to then transforming the system and applying the theory of change to the lives of ordinary people.
So thank you so much for that, Caleb. As always, I'm in awe of your way with words, and I think the very strong point that decision makers, politicians, leaders don't often have a backbone when it comes to defending the rights of vulnerable minorities, of LGBT people, of our communities. And it's the job of activists quite often to be the backbone or to encourage them to find their own backbone. And I think it's a job that I certainly know that you do very well. I think that takes us to the kind of end of the conversation. I'd like to kind of thank both of you, as always, for joining us, for sharing your insight, your expertise, your wisdom with us. And to thank you for the work that you do for the communities in your country and our communities across the world. I guess to kind of sum up, I guess, a couple of thoughts that I think have kind of really kind of been surfaced through this conversation. And I think, you know, there is the point that this is a complicated and long process that requires strategic shifts as we go. The example in Botswana of changing our positioning, changing our strategy to deal with the immediate freedom of association case, and then shifting that strategy to deal with decrim, I think is a really kind of clear example of having a kind of flexible, sophisticated approach to change through the courts is really kind of vital in building success and encouraging success. I think also the point that you both made about the need to have an eye outside of the court, that it's not just the arguments being made by the people in suits in a wood-paneled room that are important. It is the arguments that we make to our communities, the arguments that we make to the wider community, the arguments and the conversations that we make to our political leaders, our leaders in government, that do two things, that help strengthen that activity in the court. And I think Anna, as you so eloquently said, takes the case out of the court and into the community where it actually can become operationalized, instrumentalized. And actually that's where change actually happens, not necessarily within the kind of four walls of a courtroom. And I guess kind of the final kind of takeaway for me is that point that litigation is just one part of a much bigger puzzle that we're putting together. It's an important part, but the story isn't just confined to litigation. And it's not just, and it doesn't finish when we just get to the end of a court case, that the court case serves a broader purpose in bringing dignity, equality, justice to our communities and the communities that we represent. So I'd like to thank both of you once again for joining us. I'd like to thank those of you in Copenhagen and beyond who've listened to us over this last 45 minutes or so, and wish you the best for the rest of your week at Copenhagen 2021. I hope it's fruitful and enlightening and above all, a lot of fun. Thank you very much.
Thank you. Bye.
No problem.